Uh, Hi everyone, welcome to today's session of Born to Blossom. My name is Rekha Busa. I'm your host for today's show. Uh, Today's iWomens.net is an cloud-based platform where that encourages entrepreneurs. This is the best place to market your products and also your events and competitions. Today on the show, we have Miss Janetha Kancharla. She is an attorney based in Virginia. She practices law of immigration. Today, she's here to talk about the recent USCIS visa bulletin October 2020, and she'll be answering a lot of questions on green card processing and filing. So welcome, Janetha, to today's show, and thank you so much for taking time and coming online for answering all these questions.
Thank you. It's my pleasure to be on iWomens. Thank you.
Can you tell us a little bit about yourself?
Yeah, actually, I did my LLB, law degree from Osmania University, and then I immigrated into this country after I got married to my husband. And after coming here, I did my master's from IUPUI, Indianapolis, and in law. After getting my master's degree in law from the United States, I did the New York bar exam. And then after that, since I have been practicing almost more than 11 years. And I've been specifically, I used to practice in New York, as I'm licensed in New York, different laws. But as I am an immigrant, went through all the process, and then which really made me uh, you know uh, draw towards this specific field, immigration law. So that's how I've been into practicing immigration law.
That's good. I mean, even so, you have a personal experience and you're using that in your profession as well, right? So that's good. So, can you tell us a little bit about the recent USCIS change? And I've read that EB3 filing is faster than EB2 right now. So, can you talk a little bit about that?
Yeah, sure. Usually, I mean, there are the USCIS and the Department of State. These are two different, departments, and then have two different jurisdictions. So, as every month, I mean, if most of them, all the immigrants are aware that every month, second week, we usually get the visa bulletin from the State Department. But this month, I mean. Till October 24th, they didn't publish any, and then people really got anxious about what's going on. But bottom line, on October 24th morning hours, they did publish the visa bulletin, which is a good news for many of them, and for some of them it's a disappointment, especially those who are into EB2. So those who are into EB3, it really jumped in 5 years ahead. And then now still, when you compare EB2 and EB3, it's almost I mean, more than nearly into the 5 year difference. So I mean, we'll share our own experience. I mean, in the past 10, 11 years, whenever we look back, I can just hardly count on how many EB3s we filed. So, most of them, the requirements are into EB2. So, but the question in here is, as I think it's been 6 years right now. Before the 6 years, how the Department of State used to do the visa bulletins, there is only one table for everything. There are no final action dates, there are no filing dates, everything in one go. And then whatever the dates, those visa numbers that are available, they just publish that. And as per that, I mean, people used to file the 485, and then no interviews, just if the dates are current, and then adjudications, all the paperwork are current, properly filed, then they used to have the cards in place. But around 6 years ago, they created two different charts. One is the final action dates chart, and one is the filing dates. So by doing this, the difference between the final action dates and the filing dates are, when you look at the final action dates, that's when I mean, you are eligible, and then you will be getting your green card pretty quick once they adjudicate on the 485. But as per the filing dates, they are providing you this kind of at least the eligibility to go ahead and then file the 485. So once you file the 485 along with your EAD and advanced parole, it's a huge flexibility in there for it's almost like you can use it as, the flexibility, like how you use the green cards and stuff like that, like a step below the green card. So once you stay with the same employer for 180 days, and then, with using the AC-21, you can, move around the jobs, and then, accept different offers, and then, you really don't have to deal with the visa stampings and stuff like that. And then, but definitely, if one don't want to really be on the H-1B, they don't have to. But most of the time, attorneys suggest them you have the H-1B as a fallback status, because if something happens to your 485, at least you'll have that kind of, cushion as a H-1B, so you can fight for it. So given these, right now, when we look into the final action dates, for EB2, it's September 1st, 2009. And for EB3, the final action dates are January 15th, 2010. But when we come back into filing dates, which is a huge celebration for so many people, for EB2, May 15th, 2011. And then for EB3, it's 1st January 2015. So those who are having the priority date is based on, when you file the labor. So, it will be reflecting in the priority date in your I-140 copy. So as per that, if you are eligible under these two categories, whether it is the final action day or dates or the filing dates, so one is eligible to go ahead and, file for the 485s along with their work permits and also the advance paroles, which gives them the flexibility to travel in and out of the country.
So is the priority date similar to the filing date or the final date? So what is which one of these is a priority date?
See, there are final action dates, filing dates. Those are completely different from the priority dates. Priority date is
Okay.
based on when the labor was filed.
Yeah.
So that will be reflecting in your approved I-140 copy. So as per that, just go ahead and check, filing dates and final action dates. I mean, we don't even have to ask them to check. They have been waiting for this moment, years now. So, it's already registered in their mind. So, now everybody knows, what is going on, how they can, actually do it, because everybody is not in that kind of situation where to, go ahead and file it immediately. Some people have to downgrade it to grab that opportunity under. So, we'll see as the questions pop up from the viewers, we'll go ahead and take, but, that's what I would say.
So do you recommend downgrading? Because I know that a lot of myself and a lot of my friends, my husband, all of us has our green card processing going in EB2. So since the EB3 is going faster, do you recommend downgrading it to EB3 at this point?
I mean, it depends upon the priority date, what you have. This doesn't happen that often, because if you look into, EB3 moving ahead than EB2, it happened once previously in 2013 with, Chinese nationals, not with the Indian nationals. So, they did had that kind of movement in EB3 in 2013 moving forward. So based on that, many downgrades happened during that time frame. So, similar to that right now, it's applicable to all the, Indian nationals. So if one what kind of priority date they have, and then, it all depends upon that. But definitely, if you are not eligible under the EB2, I would definitely say that, go ahead and have a conversation with the employer, and then the, your corporation immigration attorney, and then, chalk out a strategy for that, and then, go ahead for, downgrading it from EB2 to EB3, and then filing concurrently. Like, when you want to downgrade, it's kind of, refiling the I-140. And as the dates are current, the filing dates are current, so, they can also file 485 concurrently. So technically stating, it's filing the I-140 and 485 concurrently together when you are downgrading it.
Okay. So you do recommend, so based if someone has a priority date as 2016, 17, so do you so you do recommend downgrading it to EB3, right?
That Yeah, I mean 16, 17 it's still not available right now. It's only till January 2015. But let's say in EB2, if somebody is at 14 or so, definitely if they downgrade, 2014 and 15 before that, so before the priority date of January 1st, 2015, they will, absolutely benefit from this date.
Oh, that's good. And so, what is the process of downgrading, and like, can you do it in the premium processing? Can you do it in premium?
The process for the downgrading is, I mean, the employer has to refile the I-140 based on whatever the actual requirements are that were already submitted as per, the labor that was filed in EB2. So if one already met the EB2 requirements, definitely defaultly they'll meet the EB3 requirements. So looking into those, using a copy of already, submitted, labor application, they can go ahead and then, do a downgrade. But unfortunately, USCIS don't accept these petitions in the premium, like the I-140, because only when the original labor is available, that's when they actually accept in the premium. So previous, as per our experience, and then as per the rule, though you have, if you are filing it in premium, most likely they'll try to send the premium form and the premium check back accepting rest of the petition. So you cannot do the premium process, but you can concurrently, as the dates are current, the filing dates are current, so you will go ahead and then downgrade it by filing the into the EB3 category in the I-140, and also concurrently file the 485. So by doing that, the I-140 gets receipted, the 485s and the EAD 765s and the advanced paroles I-131s will get receipted. So you'll just wait, as the things move forward based on the USCIS caseload. It might take anywhere between 6 months or more. So to have the actual EAD and then advanced parole, because one needs to appear for the biometrics and stuff like that. So, but unfortunately, premium is not available. But I don't think so. It's going to be make any big difference on those lines. But for some people, those who have, like, let's say, for example, if they have the I-140 under the EB2 and then they move to a different employer right now, some people they are in that situation where the labor was filed by the current employer and they have the labor approval readily about to file the I-140. With this huge forward movement in the dates, I think they can, if they have the original approval, they can definitely do it under the premium process, and then go ahead and get those done, filings the I-140 in the premium, and then along with the underlying 485 and then 765. So you will know and based on the premium, the I-140 will get quickly adjudicated, because premium it will cost $440 extra, and then the case USCIS usually guarantees that they'll adjudicate the case in 15 calendar days.
Okay. So I have a question from a listener. So his question, the question is from Raju. He's asking, my parents are here for the last 10 months. Their visitor visa will expire next month. Do you think it's safe for me to apply for the extension, as the travel is not safe? What do you recommend? Thank you.
Usually in a given year, one can stay, up to 6 months. Looks like, this is the, first extension you have already done, going with the second extension. So make sure, I mean, firstly, I really don't recommend that, but maybe based on the parents' age and stuff like that, and then the case rise, in India, how it is, the virus. So maybe using that you can do it, but I definitely recommend having a doctor's letter, and then looking into their age. It depends upon case to case. You can, but I'm not really sure whether it will be in an approvable position, because this is your going to be your second extension. but there should be a very strong reason for it. Of course, the Indian case rise is one of the strong reason, but you cannot just file based on that.
Thank you. And we'll going back to the EB2, EB3 processing. So you said the premium is not available if someone is not with the employer. So they got approved. They have an approval I-140 from a different employer, and they changed their employer recently. So can they still go and downgrade to EB2, EB3?
Yeah, a lot of people unfortunately are in this situation. We have been receiving calls, mostly from those people where, because just before the pandemic started, or maybe in March, around April, everybody feared that there's going to be a recession, or kind of, most of them, losing their jobs. They just left their, H-1B employers, and then took full-time opportunities, which is good for them, because full-time. But one downside of it is, as if they are layoffs, and then if the corporation is not filing the labors in that situation, then definitely you have to go back and then try to see whether employer is willing to have that position available for you. Of course, you can definitely go back and ask, and if the employer is willing to, then I think you still will have that kind of opportunity. But you can do it only with the cooperation of the employer, whether they also have to strategize how to file it, because they might have other filings in place. And then, in case once the filings happen, if the ability to pay issue pops up, how they are going to address it. There are several things that one should really discuss with their employer. And then I think the employer in turn will have a brief conversation with the attorney, with their corporation immigration attorney. I think most of them will go based on that advice. But if the employer is willing, bottom line, yes, there is a chance for them to go ahead and downgrade.
So it depends on the rapport they have with the employer.
That's correct. I mean, it's not about the rapport, but again, employer keeping that position open for them, and then willing to move forward, offering the same position.
So can someone have, like, I know that you can apply multiple H1s like that. Can you have multiple like I-140s? One could, like, one through EB3 and one through EB2?
Yes, definitely. One can hold multiple H1Bs. Similar to that, one can have multiple I-140s, and also one can have multiple 485s. I mean, going at the same time. Because if you go back and look into it, I mean, based on our, conversation, people, those who are with the initial employer having a priority date I-140, and then somehow they change the job to have a different opportunity, move forward with them, and again filing the labor with that company, and then doing the I-140. So if their prior position is for the EB2, might be the recent I-140 what they got might not be the same category. It might be EB3. So, but good thing is that they can still keep the priority date from their previous employer, if they are with that same employer after the I-140 approval for 180 days. So they can port it, and then yes, they can have multiple I-140 approvals, one in EB2 and one in EB3, with
Yeah,
different
unless,
employers or with the same employer sometimes.
oh, with the same employer too. Okay, that's new information for me. Okay, so so can have multiple only in the case with if the previous employer didn't revoke their I-140, right?
Usually, as per the rules, it's highly unlikely they will revoke, because H1Bs, they are obligated by the rule, based on the back wages, lawsuits that they stem out of that. But, I-140, they don't have to. Most of the time they can, keep it open. So, if they have that kind of position, if they want the employee to come back and work, they can always offer. But if the I-140 once it is revoked, it depends upon how it is revoked. Let's say it is a prompt from the USCIS saying, the initial I-140 was filed, there is a fraud involved or any misrepresentation. In that case, I would not really suggest to use them. But I mean, once the I-140 is revoked, it is a little bit tough to, go back and then, do something on those lines once it is withdrawn or revoked. But as long as it is active, yes, you can definitely go back and downgrade.
Okay, that's good to know. So how long does the process take once you file the I-480? So how long does it take for me to get my green EAD?
So once the 485 is filed, I mean, pretty much it might take anywhere between, 6 to 8 months. But, USCI, if you go back and see the USCI's dates, they always keep, updating based on their caseload. But anywhere, I would say, around 6 months or more, because once you file the 485, they will be receiving those and then, issuing the biometrics, and then people will be going in the local field offices, to do those biometrics. And then again, after that, they will have the EAD and advanced parole approvals. These are for, the filing dates people. Those who have the final action dates, those might be, I mean, actual card you might receive, after doing these. Once you have the EAD and advanced parole, you might even have your green card a little bit sooner, anywhere 8 to 9 months, based on whether they will be requiring you to come for the interview or not. They might even waive. It all depends upon. But as per the 2017, rules, most of the time they try to, when they are adjudicating the 485, they try to look into how recent the medicals are, how long the 485 has been there, and then if they have to do an RFE on that. Especially these will pop up for filing dates people, down the road, I mean, years down, where you actually receive your card. So that's when, you might receive RFEs for medicals again, and also asking the confirmation from the employer who is on the record stating that, asking them to issue the 480, signing the 485J, just like a confirmation that, the same position is available for them when they offered for the I-140. It is still in a, valid. So they kind of, validate. But, the whole process, it depends upon, let's say if it is a metro city, and then, local field offices are not really having those kind of fingerprinting dates available quickly. It might take a little bit longer, but anywhere I would say, between 6 months and more.
Okay. So when do you file 485 in the entire your entire green card process? So which phase?
The 485 will be filed, when your dates are current, whether it is based on the filing dates or whether it's based on, the final action dates. So either based on either dates, I mean, you will have that I-140 priority date in there. So based on that, you will be qualified, to go ahead and file the 485s.
So someone who has in who has a priority date in 2015 January, EB3, then they can go ahead and file it right now, right?
Yeah, the cutoff date is January 1st, 2015. So prior to that, anybody has that kind of date in EB3, and then, for the EB2, May 15th, 2011. So anything prior to that, they should be eligible to go ahead and file.
Okay, so once you file 485, can you change your employer?
You can do so, based on the AC-21, but at least you should be with them for 180 days. So once the 180-day period passes after you file the 485, I would say you can change, but pretty much per the flexibility, I would say once you have that EAD and advanced parole, try to do that. Whenever you move from employer to employer, of course, you will be, updating them by filing this 485J, letting them know that, you are working under that same or similar, kind of job title, job duties. So you'll be filing and updating the USCIS whenever there is a move from employer to employer. But yes, you can after 100, after 6 months, 180 days.
Okay, so I have a few more questions from the viewers.
Mhm.
So Raghu asks, once you downgrade, what if EB2 becomes current?
Okay, so once you downgrade from EB2 to EB3, then any retrogression happens to EB3, and then your EB2 dates become current. I would say you will still be eligible, if the refiling downgrading was filed correctly. So you can use that existing whatever is approved in place, I-140 under that category, and then you can go ahead and then file under that category too. Or what you can do is, as you already downgraded and filed the 485s, so you can interfile the 485 technically, letting the USCIS know that you already have a 485 filed under the EB3 category. Now based on EB2 category, as the dates are current, you are asking them to adjudicate the same 485 under the EB2 category. So how it happens is, it's sometimes it's a time consuming activity, because you just have to write them the letter. It's not easy to get the USCIS on those lines. Like if it is a form based fee is involved in it, then definitely it will get to their attention quickly. But if you have to do this interfiling, you have to write them back and forth, and then letting them know. Sometimes it might just sit there, and people will not have that kind of time. Let's say if they are in fear of whether if the dates again will retrogress or not. So if you are not willing to take the risk of interfiling and things like that, and if you don't mind spending those kind of dollar amount on the 485, so I would advise just go ahead and file the 485 as well when the dates become current.
Okay, so I have a few more questions. The second question is, once we receive the EAD, can we leave the employer, or do we have to be with the same employer until we receive the green card?
You don't have to be with the same employer until you receive your green card. As I said, you will have that kind of flexibility. Once the 180 day, you reach the 180 day after filing the 485. So let's say you are with employer A right now and planning to take a full-time opportunity with employer B, and then if you would like to go ahead and then move with employer B based on after the 180 day, yes, definitely you can do so, but make sure that you are trying to justify by filing the 485J that you are moving within that same or similar that AC21 language triggers in. So try to comply with those.
Okay. So the third question is, what could be the impact on future dates as everyone considering downgrading from EB2 to EB3?
Yeah, unfortunately, there are a lot of people, because as it's a huge move forward, so people are trying to port it back to EB3, and then this is not good for the EB3 people. Those who are already there waiting for a long time, they are like, come on. So if a lot of numbers are coming from there, maybe by looking into it, the State Department, maybe retrogression happens, but we don't know at this time. So it's very unpredictable, always with the downgrading especially, and then going back and forth on those lines, because it all depends upon how many numbers are available, and then there are less numbers. So let's say if EB2 dates with those who are having those priority dates moving to EB3, those who have those 11, 12, 13 dates, then they are standing in line cutting short ahead of the those who have the 2014 December date. So that way he's already taking a number there. So, it all depends upon that. But yeah, but as per, the visa bulletin, October bulletin, they did leave a positive note out there saying, rapid forward movement, for the coming months. But we are not really sure because of this whole thing of, downgrading, and then, EB3 dates are far ahead than EB2. So we just have to keep a close eye on that. But if one is really eligible, nobody really wants to miss that kind of opportunity, because, this happened in 2017, that, when they opened it up, and after that, I mean, there is a very slow movement and all of those. But now again, as it opened it up, most of the people are trying to take advantage on those lines.
Definitely, yeah, I agree. Like if someone has a priority date at 2014 and they're an EB2, they'll definitely want to take advantage of this. And this the fourth question is, can you please provide more details about interfiling process?
Okay, interfiling, how it works is, hypothetically, I'll run the scenario with you. So if a person is with, employer A, and then, you are with EB2 category, but somehow as the priority date is not current, you downgraded it to EB3, and then where your priority date is current, and you'll be filing the I-140 and 485 concurrently. And you will have that, you're already in line, and then those the downgrading I-140 and the 485 along with your EAD and advance parole will be received. But somehow again, when your EB2 dates are current, then you would like to go ahead and stand in that line again. So when you are doing so, you will go ahead and then use your approved I-140 labor, and then you will let the USCIS know, stating that, hey, I already have, an EB3 485 filed. These are my dates and these are my receipt notices. So you will be attaching all those things and writing, a letter to the USCIS to seek their attention that this particular petition be given, the EB2 priority date than the EB3, because those dates are current, and then you have to, that's called interfiling. So I would say, sometimes this interfiling, to get the officer's attention, it might take some time, and then, people don't have that kind of time. They'll get frustrated, and then, they think that, maybe what if my dates retrogress back on those lines. So, for those people, I would advise go ahead and file another 485. So that way you are having, another set of 485 based on your, EB2 priority date.
Okay. So the other question is, if employer is willing to file, I think what he's trying to say is like willing to file the willing to downgrade, but ask employee to pay the associated cost. So is it legal?
I would say if they are trying to downgrade, especially for the I-140, it is, the employer's responsibility to, pay the fees. So I don't agree on that one, employee taking care of. Definitely for the I-140 employer, but for the premium they can, if one can is eligible for the premium. But for the 485, the rule says, I mean, if it can come out of the employer's pocket, that's well and good. But, most of the time, employees, will go ahead and they can bear that cost. But I-140, yes, it is the, employer's responsibility.
Okay, so the next question is, if a priority date is in March 2015 under EB2, is it a good idea to downgrade to EB3 at this time?
March 2015, it's not even current right now, but, I mean, you can go ahead and at least initiate that I-140 process. If you think that you are, I mean, if the dates remain in the similar, forward movement, and if they are going ahead, there's nothing wrong in doing that if the employer is willing to go ahead, but one needs to still wait for those dates because it's not there yet in the 2016 year. Even under the EB3 it is still January 1st 2015. But yes, there is nothing wrong in prepping yourself and then having another set of I-140 approved in a different category.
Okay, so the next question um, is there any chance of negative movement or reverse in final action dates? I think it was similar to the previous question.
Yeah, I mean, we don't know how the dates goes, I mean, there is one who predicts all of those things as per the numbers availability, but I mean, if one is watching closely the visa bulletin, I mean, it's always, a few weeks or sometimes even, days under the EB3. So we never know how it's going to happen. But as, the dates for those whoever the dates are, current under 2 and 3, and then those who are really eligible for the downgrading, they are trying to grab that kind of opportunity to be in line. So because as the rule allows you to do so, they are trying to take advantage of that.
Okay, so the next question is how long can we stay with EAD advance payroll?
I mean, I'm assuming that this question is how long one can stay with the same employer. So, as I stated earlier, it's 6 months, 180 days that you have to stay with the same employer. And after that, if you would like to make a move, then, file the 485J with the USCIS and then, try to move. And then you also have to, make sure that you are complying with those kind of rules even before moving out. Try to run it with an attorney, the immigration attorney, whoever it is, or those who are qualified, to make sure that it is a safe move to accept a new position, and then whether that position is falling under the same or similar job title and job duties. So it's very important for for an individual to make that kind of decision, informed decision, running it through, whether it is your own corporation attorney or anybody, you can, who those who are qualified, reach out to them, but make sure that you are taking that proper, the correct step.
Okay, so you already mentioned that the downgrading process might take around 6 months, right? So in that duration, if the dates become, like, example, one of the question was that if they have March 2015 as a priority date and they are in EV2, and so they decided to downgrade and they filed for downgrade to EB3. And so in those 6 months, if March 2015 becomes current, so they have to wait until the approval process is done. Then they have to do they have to wait until the downgrade approval is done to file the I-485? So how does
No,
that work?
if the as I said, under the EB3 category, it's not there in the March of 2015. It's still January 1st.
Jan, yeah,
Yeah,
yeah.
but for hypothetically, if it becomes current, yes, one can go ahead and then file the I-140 and then 485 concurrently. But let's say if it is the other way around, like once a person downgrades to EB3, refiles the I-140 and 485 under that category, and then they also have the eligibility in the coming bulletin that the EB2 dates become current and they have that opportunity, they can do so. They don't have to wait for the approval, because whatever you already downgraded, that is for the EB3 based on. But if you are still eligible under the EB2, you would still go ahead and grab that opportunity because you already have that priority date and you have the I-140 approval, based on that date, and you don't even have to wait for any of the three approvals. So you will go ahead and then file, either file a new 485, or as we just discussed, one can do interfiling as well.
Okay, so when you filed I-485, can you go out of country? Can you travel out of country?
That is a very question that for every individual, those who are trying to file the 485 right now, make sure that I mean you are staying inside the country at least by the time you have your advance paroles, because without having the advance parole, if you travel on your H or so, then it is considered as abandonment. So make sure that you are staying inside the country and then traveling after your advance parole gets approved. The reason is once it is considered as abandoned, it's difficult if the dates go back and retrogress. Then you will be uh, you know um, making that mistake of leaving the country. But everybody should, whenever they have travel plans, definitely one should update the employer and also run it through their corporation lawyer, saying that whether they are safe to leave, this is what the situation is, because yes, we all have emergency situations because we are humans, and then we have to travel because family is back home. But make sure you are making that kind of informed decision. Try to reach out to your employer, let them know this is what the situation is. Also try to reach out to your corporations immigration attorney, let them know this is what it is, and then whether they really can travel. But I would say once you file the 485, wait till your advance parole is received.
Thank you so much, like, for detailed answers you have been giving so far. And I actually don't see any other questions from the viewers. So thank you so much, Janetha, for taking time. Oh, okay. Okay, I see one more question. Um, so hi Janetha Garu and I Women's. Thank you so much for this informative session. I have moved to a new employer. Can I continue with the EB3 application from the previous employer?
Yeah, as long as the employer is willing to, you can still stay with the current employer. And then if your previous employer is willing to move forward with your filing, stating that they still have that kind of opportunity available, I think you should go ahead and grab that opportunity and then file for it.
So the next question is, how important is to have a birth certificate?
Okay. So, I mean, as part of the 485 filing, I mean, you will have to, that is one of the, documentation, mandatory documentations, I would say. But if you don't submit that, they might do an RFE. But what I would say is if you don't have the birth certificate right now, at least try to get affidavits from your, parents. Those, if you have your parents here, you can do so. But if you have your parents back home, try to get the affidavits done by both of your parents, stating this is what it is. Maybe if you are going through one of the law firm, anybody, they can provide you the samples, so that way you can get those affidavits done, get them notarized, and ask your parents to provide you a copy of that. You don't need an original for the 485. So having a copy gives you that flexibility that they can just scan it and mail it to, email it out to you, so you can go ahead and file it along with the affidavits. But I'll highly recommend either having the birth certificates or the affidavits. Do at least either one. If you have birth certificate, you don't have to worry about the affidavits. But if you don't have that, definitely at least include those affidavits in there. And sometimes they might not have the parents available. If they are deceased, if they are not able to, you can still reach out to your paternal or maternal aunts and uncles to have those kind of affidavits done, or your older siblings as well, if they are.
So the next question is, I would like to know what are the risks in downgrading from EB2 to EB3? Is it advisable to do so?
I mean, there is no risk involving, if it is correctly done, as per the, process. When they downgrade it, correctly, following the steps that are required, downgrading it from EB2 to EB3, you will still keep the EB2 one, in place, and then this is the refiling and downgrading it to EB3. So it can be done if it is done correctly. There are no risks involved, but make sure that you are choosing a knowledgeable attorney, going ahead and then dealing with those, because sometimes I think if the corporation already has an attorney, I think they should be able to handle all of those things. But yeah, there are no downside or risks involved in it.
Okay. So the next question is, what happens if the child who born in India turns 21 years old after filing I-485? Is the child still eligible to receive green card even after they turn 25 years old, 21 years old?
Yeah, as you are filing the 485 for them at that age, the age, as per the CSPA, now you are filing the permanent residency, the 485 for them. So they should be good to stay inside the country, having EAD, they can work, using the advance parole, they can, still travel. So they should be good to continue their life inside the country. And one quick question I would like to clarify the previous one when said, what are the downsides? Maybe if we are looking into from the employer's perspective, sometimes, USCIS might come back and then say that whether you still have that kind of opportunity available and show us, the ability to pay requirement for this, EB3 filing. So you can expect some kind of, RFEs on those lines, but not a real risk. But as long as employer is willing to provide you with that kind of documentation, I think you should be going I would definitely recommend going ahead and then grabbing that opportunity.
Okay, so the next question is, I have I-140 with employer A and now with employer B. So now with employer B, then employer A is willing to file my I-485. But my question is, do I need to switch to employer A immediately, or is there a time frame when to switch to employer A before filing GC?
So it all depends, as the GC is a future employment, as long as, employer doesn't require you, if they want you to come back and then start working for them on this thing, when they file the 485 for you, supporting you by doing the 485J form, I think you should definitely, it all depends upon the terms between you and your employer. But you can go back and work with them, and then not necessarily that you should go back. There is no mandatory rule that you should definitely work with them before. But one rule I would say is, once you have that 485 adjudication, technically after having that green card, work for the employer at least 6 months, so that way when you apply for the naturalization, they might look into if it is with the same employer, whether the employment opportunity that was offered to you was a legitimate one, should not raise any red flags on those things. But doesn't really, it's not necessary that you should go back till you have the green card, but it all depends upon what your employer wants you to do.
Okay, so the next question is, if I will downgrade EB3 EAD for employment or advanced payroll, is it still possible to file new for I-485 with EB2 I-140 or interfiling?
Yes, as we previously discussed, you will have two different kinds of options available. One, whether you really have that kind of patience, when, attorney communicates with the USCIS office to interfile, letting them know that, now they should consider, the CB2 priority date, because it's a time consuming, there is no direct form kind of that we will be able to communicate with them. So, if one is okay with those timelines, they can do the interfiling. But most of the time, if the dates are not going to be available, and if one fears that retrogression might happen again, then I would say go ahead and then file another set of 485 per your EB2 priority date. So that way you are filing and securing one in a timely manner.
That's good to know. So the other question is, my priority date is December 2011 EB2. Is it okay to file EB3? Also, later, can I use EB2 and to file I-485 in EB2 if EB2 final action date is current?
Yeah, similar to what we just discussed.
Yeah.
Yes, I mean, if it is, December, yes, you can go ahead and downgrade it right now and then file the I-140 and 485 concurrently. And then, once your EB2 priority dates become current, either, depending upon whether you can interfile or do another 485 filing, that's what I would advise.
Okay, so the next question is, what are the chances of audit if we downgrade?
I mean, this is not the perm where you will get the audit, but you will get an RFE, based on, what is in there. But as we spoke previously, definitely, the USCIS might RFE saying, asking the employer to, show the ability to pay. If the employee is still working with the same employer, it's not that difficult to, do that. But let's say in the scenarios where a lot of people are thinking to go back to the employers and asking them to file the 485s for them to support by signing the 485J, saying the same opportunity exists for them. They might see that, hey, we could see that this particular employee is no longer working with you. They would try to RFE asking the employer, how do you meet the ability to pay. And in the same process, not only with this one employee, let's say if the employer has 20 to 30 other employees, and then let's say if there are another 20 I-140s approved on behalf of the beneficiaries, they might even query for all the 20 people. I mean, query in the sense, query on the same lines in this RFE, asking to prove the employer that he is having the ability to pay for all of the approved I-140s since the date of the filing of the labor. So that will be a little bit challenging if the employee is not working for the employer. But if the employee is, still with the same corporation, same employer, I think they should not really have, any trouble, meeting that ability to pay requirement.
Okay, so the next question is, I have I-140 approved with my current employer, September 2010 EB2. However, this date was ported from my previous employer's I-140, who is out of business now. So will that be a problem at all?
It shouldn't be, because I mean, if it is not a valid date, they wouldn't port it. As it's already ported towards your current EB2 with the current employer, I think you should be good to go. If the date is, you said it's 2010, so as the date is current, you can just go ahead and then file the 485.
So the next question, okay. The next question is both main applicant and I'm sorry, I think I don't see the complete question. Okay, so it says, is both main applicant and the require and the spouse required to have medical uh, exam taken? Also, if is it compulsory to do a medical exam?
I'm advising all of my clients, to have the medicals, because sometimes, USCIS can make a decision that, I mean, why the medicals are not there, not to have those kind of rejections. But as these filings are happening based on the filing dates, down the road, these medicals are valid only for a year. So, again, it can be RFE'd and asked when the final action, and when your filing date moves towards the final action dates, then you will be again RFE'd asking for the medicals, and then another set of 485J confirming the employment. But I would highly recommend, it is, in a good scenario to, include those medicals.
So include those medicals. Is it during the I-485 filing?
Filing, yes, you have
Okay.
to, whoever, for the principal applicant, and then if you have your spouse and kids as derivative beneficiaries, then definitely for them as well.
Okay. Okay. So thank you. I think that's all we have questions from the viewers. Thank you so much. You have given so much of information today, and you were very detailed in all your answers. So I think it's like a lot of us immigrants following iWomens.net and the viewers. Uh, this is a good, very, very informative session. So thank you so much, Janetha. Thank you for taking time and answering all the questions today.
Thank you, Sureka, and especially thanks to iWomens.net for giving me this wonderful opportunity. At least that I could answer some of those questions for the community, and then hope it helped them. So thank you, iWomens, and then thanks, Sureka. Have a good night.
Have a good night. Thank you.
Mhm.